Hi. Okay. Before we begin, I thought I'd like to see how many people have actually dealt with the Nova Scotia PNP. Show of hands. How many people have submitted applications through Nova Scotia PNP? Okay, so not a ton of you. And how many were through some of the employer-based programs? One. What about entrepreneur? None? Okay, and then I guess Nova Scotia, the experience. Some? Okay. All right, so this is a little bit new for a lot of people then. So that just helps me kind of gauge of what to go into and the types of things to discuss. So, just a summary, there's 5 basic categories under the Nova Scotia PNP program. You're looking at skilled worker, the Nova Scotia experience, Nova Scotia demand, then there's entrepreneur, and then there's a newer program, which is the International Graduate Entrepreneur. So I'm going to go through each of the categories and kind of describe what the eligibility requirements are, some exclusions, as well as just kind of tips on how the application process works, what to do, what type of documents to provide, and things to look out for. So just as a general idea, there's not much because each category is so very individual. Most of the programs in Nova Scotia are either employer-based or they're entrepreneurial-based. There's only one where you do not require a job offer or you're not starting out your business, and that's the Nova Scotia demand, but only under Category B. And I don't know if anyone has ever looked into it, but Category B opens and closes faster than you can snap your finger. So it's a little bit harder to get through that one, but I'll go through it in a little bit more detail. The other thing that's important to remember for all of the programs is that you always have to have an intention to settle. I know all of the provinces say the exact same thing, that you have to actually intend to, live and work in whichever province you've applied to. But all of the provinces are starting to get a little bit more strict, and Nova Scotia is no different. I find that a few years ago, Nova Scotia was a little bit more flexible. They didn't require as much information, but now they actually, if you look at any of their guides, they're very clear. When you're explaining why you intend to settle in Nova Scotia, you actually have to provide a detailed explanation, and it actually says in bold, use your own words, do not copy from someone else's. So I guess basically they were sick of lawyers and consultants basically using the exact same wording for all of their Nova Scotia applications, and they want to make sure that the applicant has a real and true intention of settling. If not, they actually can deny the application. I have not personally ever seen it happen where they denied it solely for that reason, but they do have the authority to do so, and it can happen at any point of the application process. It can happen before a nomination is given, and it can also happen after, while the federal application is in process. So it's really important that your client understands what their requirements will be, especially for the job offer ones. With the entrepreneurial, the province has a little bit more leverage because generally it's work permit based, except for the student one, but the general entrepreneur one is work permit based. So realistically, if you get approved, you actually have to work and open the business and run it before you can actually get official nomination and permanent residence. So the province already has those applicants. They know that they intend to settle. It's the other ones that they're concerned about, especially for job offer based, where once they arrive in Nova Scotia, there's nothing really that they can force the employer to keep that person employed, or they can't force the applicant to stay with that employer. So that's why they pay more attention to those applications when they're looking at intent to reside. So the province is starting to move toward online applications. There's still a few that you either A, have the option of doing it by either online or paper-based, or the entrepreneur ones where it's mostly paper-based after you go through the initial expression of interest online component. But I noticed that the province has started to remove paper-based applications from a few of the categories. So just make sure that you're checking before you start anything. Don't use any old forms for a program that's now been converted to online only. Just always double check. Also, because they've started to move online, they do have like a representative portal, if you will, where lawyers, consultants, and Quebec notaries can actually sign up for a portal. It's pretty easy. You have to provide your information, your consultant ID, your lawyer ID, whatever the case may be. It's an online process, and then usually within a day, you're approved. I think sometimes if you start in the morning, you're approved by late afternoon. But I know that the last time I did it, I started it in the afternoon, and by the next morning, I was already approved and could start submitting applications. So I always encourage people to create one of those portals. I know that some people will do individual online applications for each client. I find that's actually harder for me because it's harder to keep track of what's going on with my clients' files. I like to be able to just see everything, know everything that's going on. I don't want to have to remember, okay, what's this client's specific login details, and have to look up every single one. So I do encourage you that if if you're going to be doing lots of Nova Scotia applications, do it through the representative portal. Plus, you kind of need to make sure that you can properly deal with the province so that they're not dealing with the applicant directly. So the province has a long list of things, or of applicants that they will not allow to apply. These ones that I've posted here are the exact same for all of the categories. Each category has its own little exclusions, and when we go into each category, I will explain them. But this is a general list of things, applicants that they will not allow. You could take a look at it. One of the interesting ones that I found is the first one, which is anyone who's received nomination under Nova Scotia within the last 12 months. So I guess they figure that if you haven't used it, or if you were denied, or anything like that, there's something was wrong. Maybe you didn't really have an intention, maybe your job fell through, maybe you thought you were going to another province and you switched gears, but they do look at that. So you have to make sure you ask your clients all of their immigration history, even if they didn't go through the federal process. You need to find out if they had ever been approved for nomination as well. The standard ones, of course, are refugee claimants, failed refugee claimants, agency applicants. Caregivers are generally excluded. You have to have legal status in the country you're applying, obviously including Canada. If you are in Canada without status and you're restoring it, you're filing a restoration application, they generally will not consider you until the restoration has been approved. Because technically, as you know, with restoration, you're basically without status until it's approved. They will not allow students studying in Canada if they're still in their studies. You have to wait until they've graduated and are on their post-grad work permits before they can apply. The other interesting one is spouses of students. So as you most likely know, people who are in Canada studying, their spouses are entitled to accompany them, and they generally get open work permits. Those spouses are excluded from the Nova Scotia programs. So just make sure you're always looking at documentation. If a client gives you a work permit, always find out how they received that work permit. You want to make sure that they don't fall under one of these exclusions. The other fun one is someone with an unresolved custody issue or any child support disputes. I've done many different programs before where clients actually are going through that, and it had never been a problem before, either because the children are non-accompanying, or it's just that the parent had agreed that yes, they can go and move to Canada, but they were just sorting out all of the amounts that were payable. Under Nova Scotia, you would actually be excluded from the program. So always take a look at that as well. If you have any applicants who have children, find out if they're their biological children, stepchildren. You have to make sure you get that history because you might not be able to even start the process if they fall under one of these exclusions. Nova Scotia, also, as most provinces do, they can change their requirements at any time. So you have to make sure you let your clients know that, especially if you've started preparing everything, you've spent hours getting everything ready, you're just about to submit, and then all of a sudden they say, okay, even if you have a job offer, these specific positions are excluded. Your clients are not going to be too happy, and there's nothing you can do about that, especially since you're most likely going to bill them for the work that had been done to date. But Nova Scotia has the ability to do that. and your client has to be aware that it is a risk. The other thing that the province looks at is if you ever applied under any other provinces. It doesn't exclude you, but they're going to look a lot closer at your intention to reside when they see that. In every single Nova Scotia program, you have to provide copies of any refusal letters to from any other provinces or federally. You also have to provide explanations if you've ever applied anywhere and it didn't go through. So they do look at it, they do pay attention, and you better have a good explanation of why your client now wants to live in Nova Scotia when last year they are applying to BC and it didn't work out. So just make sure you always have justification. Again, they're not excluded automatically, but you have to justify it. It has to make sense. So, the first program we'll look at is the Nova Scotia Skilled Worker. This is basically designed for applicants who have a job offer in Nova Scotia. So from an eligibility perspective, I like this one because it's not your standard O, A, or B occupations. Nova Scotia also allows NOC C and D occupations. There's a lot more restrictions with the C and Ds, but at least they do. There's so many others that just won't accept people in lower skills. So that's why I do like Nova Scotia for that purpose. You also have to have at least 1 year of work experience within the last 5 years if you're going to apply under the Skilled Worker Program. And if you've been offered a position in a C or D occupation, you already have to be working in Nova Scotia and have been for that employer for at least 6 months. Which kind of makes sense, just because usually the employer would have had to demonstrate that they need those positions that are lower skilled. So it makes sense that they had to justify getting that work permit, and now it makes sense that they need to keep them permanently. Applicants have to have valid status in the country they're living in, so whether it's actually in Canada or anywhere in the world. So if your client is a citizen of India and living illegally in the US, you're going to have a problem. You won't qualify even though you have a job offer. Applicants have to be between the ages of 21 and 55. Make sure you're looking at that. I once had a client who was turning 56. So we were basically excluded. We couldn't get the application together before his birthday because it was coming up in a few weeks, and he just couldn't get his materials together. So they do have an age restriction. You have to pay attention to that. All the applicants have to have a minimum of a high school, well, the equivalent of a Canadian high school diploma. So just make sure that they all do. Depending on the country you're from, sometimes high school isn't necessarily equivalent to a Canadian high school degree or diploma. So you have to make sure that you're looking at that. You also have to make sure that the applicant has the necessary, any licensing or certifications. So you would look at the NOC description for whichever occupation it was. And if it says, for example, they're going to be working as an auto mechanic, and in Nova Scotia, auto mechanics have to be certified or licensed, your client would, or the applicant would have to have that certification to qualify under this program. Sometimes that's actually very difficult because in a lot of cases you can't get certification unless you're here. So make sure you're looking at those NOC descriptions, make sure you're looking at what the licensing or certification requirements are, and look to see how you can obtain it and where you can obtain it. For the language, it's actually rather low. CLB 5 is a lot lower than most other programs. And if you have a NOC C or D occupation, it's actually only CLB 4. So if you have a client whose English isn't the greatest, and maybe they have a job here, but their employer has an office in Nova Scotia, maybe it's time to get them there because this might be a more viable option for them. Under the Skilled Worker Program, they also look at finances. So they usually use LICO as the general guideline, so that's the low-income cutoff. But unlike federal skilled worker, where those funds have to be in your bank account, the province under this particular program will also consider salary that you're being offered. Given what LICO amounts are, in most cases, your client would most likely be able to meet that requirement. The other thing is you still need to have funds in your bank account because you have to show that once you get here you can settle. But you might not have to have all of those funds that are listed under LICO in your bank account. You might be able to say, well, I have maybe $7,000, I'm single, I'm on my own, but my salary is going to be $100,000. And if you can justify it, that $7,000 is enough to settle, or maybe the company is willing to give you a moving budget, you can explain it and justify it. So they're a little bit more flexible under this particular program. Not all of the programs are like that. Some of them are very strict, so you have to make sure you're paying attention when you're looking at which category you choose for your client. The province does give priority to not O, A, or B occupations. So generally what that means is if you've got a C or D, yours might take a lot longer than someone with an O, A, or B. In addition, NOC D occupations, the province wants employer support. So what that means is that they want to make sure that the employer will assist that employee settling in Canada, maybe help them find accommodations, not necessarily pay for it, but help them find. Maybe they've got a career path, maybe the company has these training programs where someone can work up from NOC D occupation to C and then eventually B. So you've got to outline all of that. The more that the employer is willing to assert and state that they're willing to do for their employees or have already demonstrated they've done, the better it is. They'll even look, you can actually say, well, the employer is paying for all of the client's legal costs. He really wants them in Canada, he's covering everything. So you have to justify it. Everything is going to be case specific and unique. You just have to make sure you document it for the province so that they can see if it's a NOC D that the employer is involved. For employer, I think we're doing questions at the end.
Regarding this job, should you do the job of
Let me get through it first, because we're going into what the requirements are. So for also eligibility, the employer has to meet a couple of different requirements. So it has to be permanently established in Nova Scotia. It can't be like a home office-based business or something that's like a pop-up temporary business. It has to be permanent. The business had to have been in active operation for at least 2 years. So you couldn't have just opened it and then you're just starting to run it now that you're starting the application. You've got to show the company's financials and whatnot to show that there's been, an exchange of goods or services over the last 2 years. The company has to have a history of good workplace and business practices. They have to be compliant with all federal and provincial laws. That includes any labor laws, health laws. It also includes immigration. So if your client has been barred because they were violating immigration conditions, they would also be barred from the Nova Scotia program. So make sure you're getting a nice history of the employer. You don't want to go through all of this to find out that the employer has had many problems before and just never told you about them. There are some occupations where the Nova Scotia employer has to have a foreign worker employer registration certificate. So you have to see if that's required. I personally have never encountered that yet. Anyone that I've done, this is a newer requirement. So the last few that I did that were lower skilled were before this was introduced. And then more recent ones might have all been more management positions where that was not applicable. So you have to make sure that you're looking to see if that employer needs one of these certificates before you proceed with the application. The employer also has to demonstrate recruitment efforts. The only exception for that is if the employee or the applicant has a valid, the employer has a valid LMIA, or the applicant is working or going to be working in a position that's LMIA exempt. So if you can demonstrate that, let's say, for example, it's under the NAFTA professionals. Say you've got a US or Mexican citizen who is an engineer and they're coming into Nova Scotia because they've received a permanent job offer. NAFTA professionals are LMIA exempt. So you can demonstrate that the company should be exempt from the recruitment efforts because of that. The other thing to keep in mind is that your recruitment efforts have to predate the nomination application, which means that you can't not that this really happens very often, but you can't have an employer who offers someone a position on December 1st and then starts their advertising December 5th. Realistically, we all know if we were doing that application, we would have them create a new job offer before you submitted everything that had the proper date. But this is going on the assumption that clients are representing themselves and they might not understand that. But it is important to know. That also includes, with respect to the LMIA, you have to make sure that it's still valid. So if it's expired, you can't use it. Even if it's for the same position. Let's say the employer advertised for an engineer and they found someone. The person applied for a work permit, came here, decided they hated it, and they left. The LMIA might have already expired, but it's for the exact same position that you're offering to someone else. You can't use it because it's already expired. So just make sure you're looking to ask for copies of any LMIAs before you proceed with the application, because you might have to start all over again. And as we know, LMIAs take forever to process, so you have to keep that in mind when you're doing these applications. As for the job offer, again, as I said, it can be a knock O, A, B, C, or D. It has to be full-time or part-time equivalent. Well, actually, no, I think they're pretty tough on full-time. It has to be permanent. It has to be located in Nova Scotia, which kind of makes sense. And the job has to meet the prevailing wage. So you have to make sure that depending on where they're working in Nova Scotia, you're taking a look at what that prevailing wage is before you complete the application. If it's lower, they'll deny it. You also have to demonstrate that the position is one where there's a shortage of Canadians. So in a lot of cases, that's through the recruitment efforts that the employer would have to meet. In other cases, like for the LMIA exempt, you haven't advertised because you didn't need to, so you don't have that LMIA, you're LMIA exempt. You still need to show that there's not a lot of people in Nova Scotia who already have those skills or are readily available. So you can look up job market reports, you can do whatever you can to show that there's just not a lot of Canadians. It has to be under the strict advertising requirements that they have, but you do need to demonstrate it in some way or another. And then the standard is the position can't be contravening any bargaining agreements, union disputes, any of the standard things that generally they don't allow under LMIA applications. So, for advertising, as I said, you're exempt from advertising if it's an LMIA position if you have a valid LMIA or an LMIA exempt position. Everyone else has to meet the advertising requirements. It's very similar to the general LMIA, but I find it's a little bit more flexible. So you have to advertise in 3 different publications, one of which is national in scope, very similar to Service Canada. The ads have to remain active for at least 4 consecutive weeks. So make sure that there's no break in the advertising or you'd have to start all over again. The publications have to target an audience in Canada which is basically appropriate for the position. So if you have like a management, like a senior manager, if you advertise on Kijiji, they're going to question, why you've chosen that as your source. You would have to have more high-level options, such as, Workopolis, Monster, or any professional websites that, cater to those occupations. So it has to make sense. Don't just stick with whichever is free to benefit your client or whichever seems the easiest. It has to be appropriately tailored. The ads have to be obviously either in English or French, and then the standard things that have to be included. These are very similar to Service Canada's requirements for LMIAs. You've got, company information, address, telephone number, position, job duties, any skill requirements or qualifications, and then the location of work obviously has to be in there as well. And all of the ads must occur in the 6 months prior to the date that you offer the job or you proceed with the application. So they can't be older than 6 months, and they can't have happened after you've offered the position. So just making sure that they're still valid when you're going through the application process. So for the skilled worker program, there are very specific exclusions. You can't, so if you're being offered a position in a skill level D, remember you have to have 6 months of experience before you can apply. 6 months of experience with that employer in Canada before you apply. You can't do that if you're on a postgraduate work permit. I'm not quite sure why they do it that way. Well, I have a good idea. I think it's because they want you to have an LMIA-based work permit to justify why those positions are definitely needed, that there's not Canadians who can do such a low-skill job. I'm assuming that that's a reason, but I just find it's funny that, you know, you've got someone who went to school, you know, they spent all that time here, they've got a valid work permit, they're not doing anything wrong, but they would be excluded from this program if they're being offered a job in a not D-level occupation. They also exclude any seasonal, part-time, or casual employment. Obviously, you're excluded if the job is not based in Nova Scotia. So if, let's say, for example, the company is very much located in Nova Scotia, but you're primarily going to be working in PEI for the duration of, you know, that's where your job is essentially located, it's not going to work. They're not going to offer. Both the employer and the job have to be in Nova Scotia. They also won't accept any sales position if it is commission-based. They won't accept any self-employment, so make sure you're looking at that. And they also look at majority shareholder. So there's a lot of times where you might be the majority shareholder of a company, but you don't consider yourself self-employed. They will actually look at that. And your client would be excluded. So just make sure that there's not that connection, or you can't apply into this program. The other thing that you're obviously excluded from, which makes sense, is if you're going to be starting your own business, which they have entrepreneurial programs, so you can actually move towards one of those instead. You don't need to go through the skilled worker. So for the application process, it's a joint employer-employee application, so both components go in together. So the application for nomination is submitted, again, with both the employer and the employee documentation. It's reviewed by an officer. Usually it takes around 3 to 6 months. They don't guarantee processing times, as no one does, but the rough time frame is usually around 3 to 6 months. Sometimes they'll ask for an interview. I personally have found that none of my clients under the skilled worker category have ever been called in for an interview, but they have the right to do so. If your client is approved, they can actually apply for a work permit. It would be employer-specific, which means you cannot apply under the open bridge work permit, even if they're already here with a valid work permit. You would actually have to apply through one of the provincial agreements. So that's section 204. So just make sure you're applying under the right one. I had a client once who applied for a work permit and he was already here. So he contacted us after he received the nomination, and he contacted us because he got this refusal letter on a work permit, and he thought that that meant something was wrong with the nomination. It wasn't, he just applied for the wrong type of work permit. So just make sure you're applying under the right category. If the province intends to deny the application, they will actually give your client an opportunity to respond. So they'll send a fairness letter, and your applicant has 10 business days to respond. I've never had this happen, so I can't say 100%, but the guide is very, very specific. They will not give extensions of time unless there is a medical or some sort of real valid emergency. So you need to make sure you've got, it's hard to prepare for a refusal because you don't think it's going to happen, but if you do get that refusal, or you get that fairness letter, you can't delay. Don't hesitate calling the client because you don't want to give them the bad news. You need to call them immediately and start working on everything because you only have 10 business days, which is actually not a lot of time. They will consider both new evidence as well as maybe old evidence that you had forgot to submit or maybe that you hadn't explained properly. So just make sure you're putting together a nice strong package if you're responding. If the nomination is approved, then the applicant can apply for permanent residence through the federal government. Current processing times are approximately 15 to 18 months. And then after they're approved, they can immigrate to Canada, to Nova Scotia specifically, and they're actually required to report to the province within 30 days of their arrival. And they generally have to provide proof that they've settled in Nova Scotia. Usually they'll ask for things like copies of driver's license, health cards, things that you would have to show that you've actually established yourself here. So if your client intends to fly into Halifax and then take off to Ontario very quickly, it's going to be a problem. They actually have to show their settlement in the province. They don't do a lot of follow-up, and it's not as strict as the entrepreneurial programs, but you still have to provide this material. As I've said, the province is moving towards online applications for everything, but at this time, at least as of earlier this week when I double-checked, for the skilled worker, they are still doing both online and paper-based. So you do have the option. Make sure you're following the document checklists very carefully. They do provide very specific information of what should be provided. With reference letters especially, you want to make sure that every single detail that is listed in the checklist is in those reference letters. Don't have a reference letter that's 3 lines long, they won't accept it. Don't have a job offer that doesn't include every single fact. It will be a problem, you can be denied. You want to make sure you're going through that very, very carefully. If you're doing it online, interestingly enough, any document that has an image has to be scanned in color. So when you're asking your clients to send you documents, it's easier for them to just send it to you in color. If it's in black and white, they have a problem because for some reason they think that it might be fraudulent or it might have been edited. So just make sure you're paying attention to that. The province also has very specific size requirements for uploading documentation. I mean, obviously, you can't really upload it because it'll give you an error message, so you'll know if yours is over. But just make sure you're looking at that. And also, you can't, I guess it goes without saying, you can't enhance or edit any documents. Sometimes it's not a deliberate thing. Sometimes I've had clients who give me documents and they've handwritten on the documents different things, pointing them out to me. Well, that's great, except now I can't include it in the package. So make sure that your clients give you clean copies of everything, and then they can explain it separately to you, just because it can be a problem, because they'll see it as that you try to enhance or edit it. If you're doing a paper-based application, same thing, pay attention to checklists. Also make sure that you don't double-side anything. I don't think most people do anymore. I know that I've worked at a firm once that they were trying to do that, trying to move towards double-siding to save paper in the environment, which is great, except it doesn't work for almost any immigration program. So just make sure that everything is single-sided. They also have things about binding. Don't put in binders, folders. Make sure you read it carefully. Ontario used to be insane about that stuff. And I actually had a colleague of mine who had her package returned because she had, I think, 2 paper clips on a page instead of 1. And they returned the entire thing. But I think that was maybe just an overzealous officer. But either way, make sure you read it and make sure you're paying attention. You don't want something returned because of something silly that you could have avoided. From supporting documentation, this is not the exact checklist. This is just generally a summary of the things you'll need to provide. The language is something I wanted to point out to you, because if it's in an O, A, or B occupation, your client might not have to do an English test. If their first language is either English or French, you're exempt from the test. If it's a C or D occupation, it doesn't matter if your first language is English and that's your only language, you still have to do the test. So it's actually something that's a little bit beneficial. Maybe to a client, I've had clients before who were born and raised in the US or the UK or Australia where English is like the language, but they don't perform well on the English test just because they're very bad test takers. So this is the type of program for them. It's because they don't have to take the test unless it's C or D. So this is a really great program for that. For the employment, make sure detailed reference letters are provided. You do have to show that you've had that experience as one of the eligibility requirements. You have to, if the experience is in Canada, I generally always provide tax documentation and pay stubs. Even if the experience is in another country, if that material is available, I generally provide it as well to back up those reference letters. It's not mandatory under this specific program, but I do it anyhow because I'd rather my case be strong. I don't want them coming back to me asking for more things later on. It just delays the process. For the arranged employment component, there's a list of documentation that the employer has to provide. Take a look at the checklist. There's forms, there's documents, and then you, of course, have to provide the advertising documentation or the valid LMIA or proof that the position is LMIA exempt. For settlement funds, as I said, they will take into consideration the salary you've been offered when they're looking to see if you meet LICO, but they still want your bank statements for the last 3 months. You do have to have both, only because it costs money to arrive in Canada and find an apartment and doing those things that you probably haven't received your first paycheck yet. So they do want to make sure you do have some funds combined with your salary. So make sure you're providing both. Don't just jump into, well, here, my client is being paid 100 grand, it's enough, it's more than enough. That's true, but they've got to have some money in the bank as well for those initial startup settlement costs. For permanent residents, this slide is pretty much going to be the exact same slide for all of these programs. It's essentially the same. When you receive the nomination, you have 6 months to apply for permanent residence under the non-express entry ones. Once you have permanent residence, once you have the nomination, and you filed your permanent residence application under this program, you are eligible for the work permit, employer-based. Remember, it's not the bridge open work permit. And of course, as with everything, the government can refuse you, even after you've received nomination, if they have any concerns about inadmissibility, your intention to settle, intention to become financially established, they think that you're going to go on social assistance, or you just, it's clear that, usually if you have a job offer, it's harder for them to prove that, but they can technically. They use it more often if the employer pulls the nomination, which generally would eliminate the application altogether, because that was the whole basis of this application. Or if, let's say, the company is doing very poorly, and it's been in the news that they're going to be going bankrupt, things like that, the federal government, if they find out about it, they can use it to deny your application for permanent residence. And then if the province obviously withdraws, it would also lead to a denial of the application for permanent residence. You could, I suppose, if you have a pending application, let's say the employer decides that they can't offer you that position anymore, you could try to salvage the application by contacting the province saying, listen, here's another employer willing to help me out. Can you please expedite it so that my permanent residence application isn't denied? Or if the person's already in Canada, maybe you could try to make H&C submissions to explain, very special circumstances why they should be granted. But in most cases, they'll be denied. So that's generally the skilled worker. So it's for people who are either in Canada or abroad. It can be any of the NOC codes. You just have to make sure you're looking at the age restrictions. You're looking at if the employer has to meet the advertising, and you have to make sure your client can meet the financial requirements. So that's kind of like a general overview of that one. So, next. Nova Scotia experience. So the province has 2 programs that are express entry based. So that first one we discussed is not express entry based, which means that if you receive nomination, you can't then use that to get the 600 points for an express entry application. You can only do so through the Nova Scotia experience or Nova Scotia demand. Those are the only 2 express entry friendly programs. So, with Nova Scotia Experience, it's basically the CEC program, the Canadian Experience class, only it has to be experienced in Nova Scotia. So you have to have 1 year of experience within the last 3 years in Nova Scotia. It has to be a position that is not O, A, or B. You had to have gained the experience under valid work authorization. They do have an age restriction, which the old federal CEC never had, so make sure you're paying attention to that. It is between 21 and 55. Again, you have to have the equivalent of a Canadian high school diploma. And then there is a language requirement. The language here is a little bit higher than a skilled worker. So if it's a NOC B occupation, it's only CLB level 5, which is same as skilled. But if it's a NOC O or A, you have to have a CLB level 7. With this one, you have to do the English test. And then, of course, you have to demonstrate your ability to become economically established in Canada. Usually that's really easy to do because you're already, in most cases, living here, or at least you're still living here, or you had lived here. You can show that you were able to support yourself. It's not job offer based. Well, it's not job offer based necessarily. You just had to have had that experience. So usually most clients will be able to demonstrate that. What they don't allow any self-employment, any unpaid experience, so make sure that they weren't doing like an internship or volunteering. Any experience obtained outside Nova Scotia, so let's say that they worked for a company where they were spent 6 months in Nova Scotia and then they were sent to New Brunswick for another 6 months, that doesn't count as a year. You'd have to come back to Nova Scotia to do another 6 months to make sure you have the total 12. Any experience obtained while studying is also excluded, which is very similar to the Federal Express Entry system for Canadian experience points. They also don't allow experience while you're studying. So just make sure you look at the dates that they were issued their post-grad work permit to make sure that it all qualifies. Even if there's, let's say, 11 months under the post-grad, but they started early when they still had their study permit, that 1 month wouldn't count. So just make sure you're looking at those dates. In this program, it does not allow NOC C or D occupations. It has to be O, A, or B. And you also can't be intending to work in one of those positions. Being honest, there's very few clients who have worked in, O, A, or B, and then all of a sudden are going to declare on their forms that they're now going to be working, in a very, factory low-level job. It just doesn't happen very often. But if for some reason that's something that they might have a future career in doing, make sure that you're not disclosing that in the application because it does exclude you. This is the interesting one. You can't apply to this program if you are the spouse or common law partner, parent, or grandparent of a Canadian citizen or permanent resident. So let's say you immigrated to Canada and you forgot to disclose your spouse before you were landed. Technically, you can no longer sponsor them anymore because they've been excluded and they're inadmissible to come to Canada under the sponsorship process. You cannot use this program as a workaround. You'll have to find something else, maybe Federal Express Entry, for example, but you can't use the Nova Scotia program as a way to get your spouse status in Canada. You also can't apply if you're working in a sales position, which is based on commissions. So for the application process, as I said, this is an Express Entry program, so the first thing you have to do is create your Express Entry profile. And then once that profile is created, you can submit the application for nomination. You can't do the nomination first, or you can't be considered into this program. You have to provide like your profile number and things, so it is mandatory. Once the application is submitted, it takes around 3 to 6 months to process. Again, technically they have the right to ask for an interview. I have not really seen an interview yet for someone in this particular category, but they have the right to do so. If you're approved, you will basically receive that invitation through your Express Entry profile, and you have 30 days to accept it. Make sure you do. Don't forget about it. If you forget, you have to start actually the process all over again. As with a skilled worker, if the province intends to deny your application, they will issue you a fairness letter, and you'll have 10 business days to respond. Because this is through the Express Entry system, processing times for permanent residents are obviously much, much faster. Instead of 15 to 18 months for skilled workers, you're looking at about 6 months under this particular program. And then as the same as the skilled workers, if you are approved, when you arrive to Nova Scotia, well, in most cases you're probably already going to be here because it's the experience program, but you might have left and then are returning. Either way, whether you're here or you're not, after your landing, you have 30 days to report yourself to the province and provide all your contact information to show that you are settling in the province. This is purely an online application. There is no paper-based option. Again, make sure that you're paying very close attention to the document checklists, especially for the work experience in Canada, though the requirements are a lot more strict than skilled worker, and they also look at the Canadian credentials. So as I said, you had to have had a high school diploma that's equivalent to a Canadian one. You actually have to get an ECA report for this program. So make sure you're looking at that because ECA reports can take a long time to process. So you want to make sure that you've got that. Again, it's an online application. So you have to make sure everything is in color if it has an image. You want to make sure that you're not going over the size requirements, that everything meets their requirements. From a supporting documentation, The two that are three, I guess, that I wanted to point out. I had already said earlier that you need an English test, regardless of what your first language is or which NOC code it is mandatory for everyone. For education, as I just said, you have to show that you have an ECA, to show the Canadian equivalent of a minimum of a high school diploma. The employment is where it's a lot more extensive than the skilled worker program. In addition to those detailed reference letters, you have to include, it's mandatory, you have to include pay stubs. If the company uses employment contracts, you have to include that. I always say also include any T4s, notices of assessment, things like that, just because it's further, it shows more. Or maybe they're not working for the company anymore and they receive a record of employment, the ROE, saying that they're no longer there. Anything that documents their employment in Nova Scotia is very helpful. When you're doing the reference letters, you've got to make sure that it does confirm that they're doing the duties that were outlined in that NOC code. It's very similar to the federal program or federal express entry, where they do look at that. If your NOC code has, a list of things that you're supposed to be doing, and the employer gives a reference letter that has one sentence that tries to summarize it all, it will be a problem. You've got to break it down. Also, don't just copy and paste from the NOC description. If you do that, they will become suspicious and they will have a problem with it. You've got to make sure you're looking at what the person's actual duties are and you're comparing them with the NOC description, making sure that they do actually essentially mean the same thing when you're providing them. At my firm, we always do the reference letters on behalf of our clients. We never let the employer just do it themselves because they rarely get it right. And so we always start off by saying, send me a copy of the company's official job description, or if they don't have one, send us a description of what you do. And then we take that and we either use the exact same words with some minor amendments, or we take it and make sure that it matches with the NOC. Don't copy and paste from NOC, and don't just take the job description without comparing it to the NOC. You've got to do both. That's what you're there for, is you're there to make sure that it does meet all of the requirements. For settlement funds, you have to have the bank statements for the last 3 months. They will also look at job offer, salaries, but they do want to see that you have a little bit more funds. It's not as strict as some of the other programs with Meeting LICO, but they do look at it, so just make sure you're paying attention to that.
Move back to the employment, so proof of self-employment that needs third party certificate. What does that mean?
So that actually is an error on my part. It should have been in the skilled worker support list. I think I mixed up the slides from that component for the employment. Under the skilled worker, they do actually allow self-employment, because remember you have to have at least 1 year of experience in the last 5 years. They will accept self-employment if you can show third-party certifications. So that means basically you can't do a self-serving affidavit saying, I was employed as this was my business, I did this. No. You've got to have maybe a documentation from one of your clients, like major clients, or from your accountant or banker who can confirm all of your self-employment details. So that one actually should have been under the skilled workers. My apologies.
You mean that is the previous category?
Correct, yes.
They allow self-employed, but
They
not
do.
express entry.
Correct.
Because express entry is like CEC, right? Like, this one is like a CEC and express entry.
Yes, correct. Yeah. So once you have your nomination certificate, again, actually, you don't really have 6 months because it's all done through the express entry now. It used to be where they had an experience program where it wasn't through express entry. Now it is, so it's just automatic, and then you have the 30 days to accept it. And then once you have submitted the application through the express entry portal, you actually can apply for a bridge open work permit. So remember the skilled worker one, you could not. Under this one, you can. Just make sure that the person still has their valid work permit in Canada. It's expiring within 4 months. If that's the case, you can qualify for a bridge open work permit because it's not employer-based. That's the reason why. And then again, for permanent residents, you can be still denied even after receiving the nomination if there's any inadmissibility issues, any concerns about your ability to become economically established, or if the province withdraws your application, usually for an intent to settle. Again, with the experience, you've already lived here or lived in Nova Scotia, you've already kind of demonstrated that, so it's a little bit more rare under this program, but they technically can still do it. So for example, make sure your clients don't all of a sudden move to another province while their permanent residence application is being processed. It will lead to a denial. And you are, or your client is responsible, and thus you are, because they've retained you, to notify both the federal and provincial government, depending on what stage the application's in, of any significant changes. So if your client has moved, you are obligated to tell them that they're no longer living in Nova Scotia. It's definitely a requirement. Similarly, under the skilled worker, if that company has rescinded the offer, you are obligated to notify the province and, depending on the stage, the federal government, that that offer has been rescinded. You can't just pretend it's not happening and hope that you get a decision before it becomes public. You're obligated. Failure to do so actually can be seen as misrepresentation because it's a material fact. It's part of the eligibility requirements. So just keep that in mind. Great. So we're now into the Nova Scotia demand. This is the second express entry program that the province has. So there's two subcategories under Nova Scotia demand. Category A is job offer based. So it's very similar to the skilled worker component. Essentially, you have to have a job offer, but in this one, it's restricted to either O, A, or B occupations. They will not allow C or D. Obviously, it has to be from a Nova Scotia employer. You have to have at least 1 year of full-time paid work experience that's relative to the job that's being offered to you. You have to have the equivalent of a Canadian high school diploma. And the CLB level is 7, which is similar to the experience program. But this one, there's no exception. Let's say you have a job offer in a NOC B, they will not allow a lower CLB level. It has to be 7 regardless of the NOC level offered for this one. This is also basically a combination of the federal skilled worker program. You also have to have at least 67 points under the factors list. And I will go into it in further detail later, but I'm going to mention it right now. The points, or the factors, are almost identical between this and the federal skilled worker program, but there's very small differences that actually can render your client not having enough points. I'm going to show you exactly where the differences are, but just keep that in mind. You also have to have an express entry profile because you can't apply to this without one. And you have to have finances. They will look at your LICO. You have to have it in your bank. The only exception is if you're currently working in Nova Scotia. Everyone else, even if you have a job offer that's a very high income, you still have to meet LICO for your bank statements. It has to be an available and transferable funds. So keep that in mind. Every program, they treat the financial requirements slightly different. This is possibly one of the stricter ones. For the employer requirements, it's also similar to the skilled worker category in Nova Scotia. Has to be a permanent establishment in Nova Scotia. Has to have been an active operation for at least 2 years. Good workplace and business practices, no violations of federal or provincial laws. And if you need, based on the occupation, you have to have that foreign worker registration certificate. The offer has to be an O, A, or B. It has to be full-time and permanent, obviously located in Nova Scotia. Again, you have to meet the prevailing wage rate, and you have to show that there is a shortage of qualified Canadians, which is the same thing that you had to do under the skilled worker program. You can't contravene any existing bargaining agreements or labor disputes of any kind. And The job offer that you're making has to be continuous and for at least 1 year after the permanent resident visa is issued. It's very similar to the federal express entry system where you're trying to get points for arranged employment. There's a lot of similarities there. These positions have to be supported by an LMIA unless the applicant is already working in Canada under an LMIA, or they're in one of the LMIA exempt positions and they've been working for the employer for at least 1 year. So again, this almost mirrors the program requirements for the federal express entry system. If you look under the definition of arranged employment, it's almost identical to Nova Scotia's. So just make sure you're paying attention to that. There's so many similarities between all the Nova Scotia employer-based programs, and you have to make sure you're giving advice about the right one. If you have a client who has a job offer, they don't meet the 67 points, they might still qualify under the skilled worker program. Or maybe they just, they prefer a program that's a lot faster. Well, if they want to qualify under this program, they have to have the LMIA. There's no other, recruitment effort option available. So make sure you're looking at that. Make sure you're paying attention to the differences. Interestingly, for this one, there's no age restriction. So with the other ones, it was mostly 21 to 55. This one, you can be older if you meet all of these other requirements. So, as I said, there's 2 subcategories under the Nova Scotia demand. Category B is the one I talked about at the very beginning before we went into everything. This is one that basically opens and closes faster than you can blink your eyes or snap your fingers. The way it works is you have to have at least 1 year of full-time paid work experience in one of the eligible occupations. So on the next slide, it will show you what all the occupations are. But if you've got one of those, you don't need to have a job offer, which is fantastic, which is why they're so popular and which is why it closes so darn quickly. Your experience is not only in one of the eligible occupations, but you have to show that you have experience that's related to that occupation. You have to have at least a high school diploma. You have to have a CLB level 7. Again, language tests are mandatory regardless of what your first language is. Again, you need to have the 67 points and an active express entry profile. And you have to have the finances, which is based on LICO. So the list of occupations, you can see there's a variety of different things. There's a bit of accounting, like financial professions. There's a few IT-related positions. Nurses are actually on the list. College instructors, paralegals. It's basically a nice little combination of things. They can actually change this list at any time, but it's pretty much been the same list for quite a while. It's hard to say when the program will open and close. I think that every couple of months they open it. There's no rhyme or reason to it, by the way. They just announce it, it happens, and then everyone scoops in to do it. So
how we can figure out when they are?
You can't.
They will announce on the website.
They announce it, you just have to pay attention to the website.
There is something very weird. People, they make some software monitor when it opens and then get the code automatically.
Yes.
We are not going to open our eyes 24/7.
No.
While
I know people who have paid for that software. Other people use Google Alerts. There's different ways that you can monitor it. Or you can just put it in your calendar to check every single day. You can do it however you want. The province doesn't care. They post it when they feel like it, and it's your job to look into it. So that's why it opens and closes so fast, because everyone wants this program. It's not job offer based. Everyone loves it.
Do you have a question?
I think we're going to do questions properly after this one. So, selection factors. This is where I told you that it's very similar to the Federal Express Entry. The factors are exactly the same. The points are exactly the same. But the criteria is not completely, in some cases, very different. I've put in red the ones where it is very different from the federal express entry. So work experience, as you might know, under federal express entry, you get points for having work experience within the last 10 years. Under Nova Scotia, it's only within the last 6 years. So you have to make sure you're paying attention to that. Also, it has to be in the same occupation. With the federal skilled worker program, you can have 5 different knocks over the period of 10 years. With Nova Scotia, it can be 1 knock within the past 6 years to qualify for those points. So that's a huge, huge difference. Another one is for adaptability. With adaptability, you probably remember with the federal skilled worker, you can get points for having previously studied or worked in Canada. In Nova Scotia, you can only do it if you previously studied or worked in Nova Scotia, and only within the last 5 years. Whereas under the federal program, it could have been really under any time period in any part of Canada. This is restricted to the last 5 years, Nova Scotia only. In addition, under the federal, you get points for having relatives in Canada, regardless of where they live in the country. Under this one, the relatives have to live in Nova Scotia. So make sure you're asking those questions. Make sure that when you're, like at my firm, we use a questionnaire that we've created that encompasses a lot of different programs. And we make sure that we ask 1,000,001 questions, which is kind of irritating for the client that they don't even know they qualify and they're providing all this information. But there's a very good reason for it. When we do our assessments, we know whether or not someone will qualify, unless they fail to tell us the information we've asked for. But we know, if we've asked, do you have relatives in Canada? We've also said, which province do they live in? We want to know that up front so that we can make sure that they would qualify for this if Nova Scotia is their best option. So make sure you're looking at all of those. Pay attention to the differences, because if you do express entry all of the time and you're getting your first Nova Scotia, you're going to forget. You're just going to think, oh, well, it's 67 points. I know how that works. And you're going to forget there are these very important differences. So under the Nova Scotia demand, there are a few exclusions. You can't have any self-employed experience. You can't be intending to work in a NOC C or D occupation. There's this one about you can't apply if you're the spouse, common law partner, parent, or grandparent of a Canadian. And you can't apply if you cannot demonstrate the settlement funds. As I said, this is possibly the strictest program in Nova Scotia when it comes to funds. They do pay attention to LICO. You do have to meet it. They don't care if you're in your category A and you have a job offer. They don't care. You still have to meet the settlement fund requirement. Unless you're already working in Nova Scotia. That's the only exception. So for application processes, you would have already had to have your express entry profile created. If you do have it created, then you can apply for nomination. So what you can do for your clients who you want to qualify under that category B, the list of occupations, is regardless of what CRS score they have, make sure they're already in the express entry pool. So the minute that it opens, you can start the Nova Scotia application and get it done immediately. You're not wasting time starting with that express entry, which is the first stage in the process. Once the application is received by Nova Scotia, it takes again around approximately 3 to 6 months. An interview can be requested. They have the discretion to do so. If you're approved, you get the nomination through your express entry profile, and you have 30 days to accept it. And if they intend to deny, you've got those 10 business days to respond. Once you've accepted it, your application will be processed for permanent residence through the express entry system, which means that it takes approximately 6 months. And then once you're approved, you can land in Nova Scotia, and then you have 30 days to report your landing and settlement in the province. Failure to do so, they can actually, they can be problematic and can revoke because it's one of the conditions. This, again, is also only an online system because it is express entry based. There's no paper-based option. From a documentation perspective, again, mandatory language results. If it's the job offer based, you've got to have all the job offer documents, so take a look at the checklist. And you have to have the LMIA or the LMIA exempt. There's no recruitment efforts option here, like with the skilled worker. You've got to prove not only that you meet the basic requirements under whatever subcategory you're applying, but that you also have those 67 points. So you've got to do both. It's similar to federal express entry, where you have to prove that you have enough either to qualify under CEC or federal skilled worker, and you have the documentation to back up your CRS scores. So you have to make sure both are covered. Settlement funds are mandatory. You've got to provide them. And then for employment, you need to have detailed reference letters over the last 6 years. And again, they will allow self-employment. They won't allow it for the job offer part, but they will allow it for previous experience. And again, this is where third-party certifications are required. You can't include anything that's self-serving. They won't accept it. They won't basically take your word for it. They don't believe people. You've got to provide other documentation to show your self-employment. When I do anyone who has self-employed experience, I make sure that not only am I getting these third-party certification letters, but I'm providing as much as humanly possible from that self-employed business. Financial statements, the company's bank records to show that there's activity. I show copies of maybe purchase invoices, things like that. Everything that I possibly can, especially if I'm relying on that experience for eligibility. It's really important that you provide it. If my client has 5 years of as an employee and just one of the years is as self-employed, I'm not as strict generally with it because they most likely already qualify without it. But if they're relying on that self-employment, you've got to make sure you go above and beyond, or else they can get denied. So permanent residence. Again, it's actually through express entry, so you don't, now that it's an express entry program, so you don't have to worry about applying for permanent residence to the federal government separately. But once permanent residence is received, so once you've done that express entry permanent residence application and it's submitted, applicants who have the job offer are eligible for work permits. It's under that provincial agreement, similar to the skilled worker. If you're under subcategory B, where it's based on having one of those occupations, you're not eligible for that type of work permit because it's not employer specific. So just make sure you're looking and look at the nomination certificate and seeing if they're listing an employer on there. And if it is employer-based, again, you don't qualify under the open bridge work permit. It is a completely different section that you're applying for. And then the same thing, you can still be denied even after the nomination is granted for any inadmissibility, inability to financially establish, or withdrawal by the province, which is usually the intention to settle. So, we're now going to do a bit of questions that anyone has had about the previous, obviously don't ask any questions about entrepreneurial, because I haven't got there yet, but any of the other programs, we can discuss those.
Any quota, do you know that for the category B?
They do, that's why it feels so fast.
It's just how
I don't know it offhand, to be honest with you.
For the demand category, you said that the relatives should be living in Nova Scotia.
Correct, to get the points.
Right. In terms of federal express entry, they don't have to live in Nova Scotia. Can they be living outside Canada?
So I think maybe there's some confusion. I was comparing federal express entries, 67 points, with if you're doing a skilled worker, versus Nova Scotia's. I was comparing the two. If you're applying under Nova Scotia, there is no other option. They have to be in. But if you're doing an express entry, you're doing express entry federal, it has nothing to do with Nova Scotia. So why would you be restricted to that?
No, but they want that the person, the relative should be, brother or sister should be living in Canada.
Yes, they have to be living in Canada. Yes, not Nova Scotia.
In demand program, the nurses needs license or not?
You mean like if the occupation has licensing requirements?
Yes, I wanted to.
So if you are having, if it's under the subcategory A, where it's job offer based?
No, the B.
Oh, under B.
Yeah.
I don't believe so, no. I don't think you have to. In fact, I don't know if any of the, I guess maybe like nurses would.
Yes.
But it's not based on working in that occupation here. It's based on having that experience, which I guess they assume that you'll eventually work here, but it's not job offer based, so it's not mandatory. I think you can go without having the licensing.
For category B, do they have to have a job and work experience related to their education? Or could it be something else?
It has to be in that list. So their work experience has to be in that list. They don't necessarily have to have the education that's related to it. Because I guess the problem is...
Look at the work experience, not the education.
Correct. So if you have, let's say, a nursing degree and you've never worked as a nurse, you can't qualify.
Yeah.
But if you've, realistically with a nurse, that's a bad example because you probably wouldn't have been hired as a nurse, but let's say one of the accounting ones that are on the list. Let's say your degree is in marketing, and then you didn't go that route, you went into accounting instead and have worked in accounting. You've clearly done the job, you can do it, you've got the experience to back it up. They don't care as much about the education because of that.
So it's the work experience which goes...
Correct, yeah. I mean, I think they would question it about the legitimacy of your experience.
Not even 1 year experience in the education? Related?
No.
No?
But what I was just saying is that they can question the legitimacy of it. So let's say you have only the 1 year, like the minimum that you need, and you don't have like a ton of documentation, or they question whether you really worked there or not, and you've got a degree that's in engineering, and you are working as like a marketing person, they might question, well, were you really doing this? Maybe they would call you in for an interview for that very reason.
Because oftentimes people who have just graduated a couple of years ago, they might have not been able to find a job.
And they work in something completely different.
Exactly.
Yeah, that's why they don't care as much about the education, but they can use that as ground if they concern that your experience isn't legitimate. So they can't deny you because you don't have the education, but they can say, we have concerns that you did perform the duties that are listed here in this letter. It's no different than if you did, let's say, the Federal Express Entry under Canadian Experience class. There's no wage requirements, obviously, for that. But if you said you were working as a manager and you were being paid $15 an hour or $10 an hour, although there's no prevailing wage requirement, they can still use that as grounds to question the legitimacy of the work experience you acquired because it just doesn't make sense to the government. So even if it's not a set in stone requirement, it doesn't say you have to have the education that matches this occupation, they can always use that if they question something else. They just use it as the basis for issuing one of those fairness letters.
Thank you.
You can easily explain it in most cases, but yeah.
You mentioned the spouse are not entitled for work permit. Which one is that? I didn't get it down.
Which one?
The spouse is not entitled for a company or open work permit, which is for, at the very beginning you mentioned, under which category was that?
No, there was the spouse of a student.
For the spouse of student, I did once with North Scotia experience class. That one is like the spouse cannot be applying for PR under this category unless he's or she is at the last year of his.
That's true, they do have an exemption if the spouse is in their last year.
Last year, yeah.
But you can't do it otherwise.
So means he, like even applicants cannot apply.
Correct.
If the student is not in the last year.
Well, the applicant can't apply because they're studying, so their experience wouldn't have been gained under a postgraduate work permit under that category.
Right. For that case, it's like she worked, she graduated in Nova Scotia and she worked 1 year there.
Yeah.
And when she's going to apply, she found out she just got married. They were like newly married, decided to get married right away. And then her husband is on the second year of the university.
But that's different because she completed her own program.
Yeah.
She graduated from that program. She wasn't an accompanying dependent on his.
Right. And she
So that's completely different.
She wants to do a Nova Scotia PNP. But because of him, it's not in the last year?
I don't think that would be the same because she's not on the open work permit based on her spouse's studies.
Right.
She has her own postgraduate.
Yeah,
so it's completely different.
So she can still apply?
I would argue that it's not falling under the same exclusion.
Just now you said over the 6 years, if a person has several work experience of a different occupation, they are not eligible.
Yeah, so under, for the 67 points, under that point system, you have to have its only experience within the last 6 years, not the last 10, and it has to be in the same occupation to qualify for points. Which is completely different from the Federal Express Entry skill.
I think it's unreasonable because they, you know.
I agree.
I had a client already. His employer is refusing to give him, like he gives him the letter of employment, states his position and date of starting the position, but doesn't give any salary or description of this job.
And he won't qualify. I mean, with the job offer-based ones, well, if it's a job offer-based one, he wouldn't qualify because there's a ton of forms that the employer has to qualify. And then if it's the experience one, the Nova Scotia experience, you're still not going to qualify because you're not fulfilling all of the requirements. You can't prove everything that you've done to meet these requirements. So they're going to have a problem with that. If you can't demonstrate it, it's no difference than saying, I've been working for the last 10 years, you know, as a doctor, but no employer will give me proof. Well, then guess what? You have not been working for the last 10 years as a doctor according to the Canadian government because you can't prove it.
Can do submission or something like that.
But, I mean, the only thing you could back up with the salary is pay stubs.
Yeah, pay stub for salary, but job description, that's the worst.
But job description, without that job description, you're nowhere. It would be self-serving to make a submission saying, I really did this if my employer is not confirming it. The only other way you could get around it is maybe have HR provide an official thing that says what the job description is for your particular position. I've done that before, where I have the standard letter, and then I include the company's official job description, and I attach them together.
Off a website?
No, not off the website, from HR. Other than that, they have complete grounds to deny it.
And that's same for assessment for the federal?
Exactly.
Same.
Yep. Okay. All right, so entrepreneurs. There's two types of entrepreneurs under the Nova Scotia program. One is regular entrepreneur, and that is a work permit-based one, where you have to first get approval for the work permit to establish your business, and then after you've actually come to Canada, established it, demonstrated that it's actively doing business for 1 year, then you can apply for official nomination, and then once they're satisfied that the requirements have been met, you can apply for permanent residence. So that's a regular entrepreneur. The second type of entrepreneur is the international graduate entrepreneur. That's for people who studied in Nova Scotia, graduated, and under their post-grad, opened their own business. Under that one, because the business had to have already been operating before they can even apply for nomination, it's not work permit based. So if you're approved, you get permanent nomination of permanent residence right away. They don't make you get another work permit and run the business even further because you've already demonstrated that. So depending on the situation, you might want to look at one or the other. So we'll start with the regular entrepreneur. To qualify, you have to be over 21. There's no max for age. You obviously have to be willing to live in Nova Scotia and actively run and manage the business. No passive investments are allowed. You have to have a legal, and I emphasize legal for a reason, net worth of at least 600,000 Canadian. And you have to be willing to invest at least 150 Canadian of your own personal funds. So those two things are important. And then you also need to have a CLV level 5 and at least 3 years of experience owning and actively operating your own business, or 5 years senior business management experience. So I just want to go back to the net worth and the investment. For the net worth, the 600,000 Canadian legal is important because with the province of Nova Scotia, unlike other provinces which often just will do their own assessments of your net worth, you actually don't work like that in Nova Scotia. In Nova Scotia, you have to have a special, like a net worth auditor, a verifier, who will actually go through all of your documentation, all of your bank statements, all of your property valuations, proof of property, any business, like anything that contributes to your net worth. that approved person has to go through it, and they will issue a report to the province to confirm that, yes, legally this is the network that you have. So I've had before lots of clients who have a ton of money, but they can't really document where it came from. And if they can't document where it came from, that auditor is never going to give a positive report, and they will not qualify for this program. So it's really important there's a paper trail, because not only will the province look at it, but as someone who, that's what they do all day, is they look at financial documentation. That's what they do. So you can't usually get around those people. And the province has a list of eligible auditors. You can't just choose anyone. You can't choose your best friend to do it for you. They have a very specific list. You have to use an approved person to provide that. As for the investment, it has to be of at least 150 of your own personal funds. So that means if you're going to be starting a business that's going to take at least $500,000 to start it up, 150 has to come from you. The rest you can do for financing through a bank. But at minimum, 150 from your own personal funds.
Good question.
Not to the end.
Okay.
So for eligible investments, you have to own at least a third of the business. You have to be providing active and ongoing management on a day-to-day basis for the business in Nova Scotia. You have to meet any legal requirements in the community in which it operates. So depending on the industry you're working or you're establishing and where exactly you're working, you might have to have different, maybe there's different environmental regulations, because Nova Scotia is not a very big place. They probably have a lot more from a community point of view. Certain communities, you can do certain things. You've got to make sure you meet all those regulations. It has to be a for-profit entity. You can't start up a non-profit. It has to be a permanent establishment in Nova Scotia. And it has to have the potential to create significant benefit for the province. So whether that's maybe creating jobs, maybe the services you provide are going to provide the benefit, maybe the products that you're selling, like you have to link it in some way. They're pretty flexible, but you have to link it some way to a benefit for the province. You can either start your own business or you can purchase an existing. If you're going to do a new business, you have to create at least one full-time or part-time equivalent job for a Canadian, either citizen or permanent resident, and they obviously can't be your relative. They want to make sure that there's no connection. You're actually creating jobs for the community. And the other thing is, it has to be relevant to the business. You can't have, a clothing sales company and hire an engineer. That makes no sense at all. You've got to make sure the job you're creating is legitimate, and you also have to meet any prevailing wages as well. So you can't just, hire bargain basement someone, just pay them as minimum as possible, just so you can create that job. It has to be a real job. If it's an existing business that you're purchasing, that existing business has to have been in operation for at least 5 continuous years. You have to actually make an exploratory visit to Nova Scotia to meet with the owners. So Nova Scotia does not have exploratory visits as a mandatory requirement. Some provinces do. Nova Scotia does not, unless you're purchasing an existing business. You also have to show that you purchased the business at a fair market price, or that you will be purchasing the business at a fair market price. So if you have a friend who owns a business, you can't just pay rock bottom prices for it. You have to show that it's fair, because realistically then the province believes that you genuinely are coming here to run it, that it is going to be a real operation. And any staffing that are currently at that operation, you have to offer either similar or better conditions. So wages either have to stay the same or possibly increase. Any vacation, you have to meet those same terms. You can't all of a sudden cut their hours, cut their wages, cut benefits packages. You can't do that if you're purchasing an existing business. And under this program, franchises are permitted. Some provinces allow it, some don't. Nova Scotia does allow it. So there's a list of ineligible investments. So you can't have, for example, any credit unions, pawnbrokers, payday loan places, any property rental or investments, businesses that are conducted remotely, co-ops, obviously nothing that has pornographic or sexually explicit material, which kind of makes sense, or any other type of business that would bring the province into disrepute. Now, interestingly, I'm not sure if they're referring to people in the medical marijuana industry. Now that it's going to be becoming a legal substance in Canada, I'm not sure if they're going to actually say you can't be owning. I know that at our firm, we've got a ton of people who have contacted us about getting work permits to operate these medical marijuana establishments. And I think that if you were going to operate one in Nova Scotia, I think they could use that last exclusion, even though it's not illegal. It would bring the province possibly into, it doesn't look good on them. I think they could use that as a grounds to deny you. So just keep that in mind. So for the application process, it's a little bit lengthy because it's work permit based. So first you have to do an expression of interest, and basically you're put into a pool very similar to the Federal Express Entry system. You're given points, and then you're selected from that pool based on the points you receive. If you're selected, then you have to submit an application under the entrepreneur stream. It's not the nomination application. That doesn't officially happen until after you've operated the business. But it's kind of like a mini nomination application. So this is where that net worth verification report comes in handy. You need it as part of that process. You can't even get the work permit until they've gone through all your finances, all your properties. They go through everything up front. That process takes approximately around 9 to 12 months. I do know of ones that have taken much, much, much longer, but it just kind of, they don't make any guarantees. That's the problem with the entrepreneurial applications. If the assessment is positive, then you are attending an interview. It's not the same as an exploratory visit, which is usually done beforehand. The interview is actually with Nova Scotia's officers, where they'll go through everything. If you can't get a visa to come into Canada to attend your interview, your entire application will be denied. So they usually give you a letter saying that you've been invited to this interview from the province, and usually that helps getting the visa. But as we all know, visa offices are insane sometimes, and they deny people TRVs for no real good reason. And if you can't get the visa, you can't qualify under this program. If the interview is successful, you'll have to sign the business performance agreement, where you're outlining all of the terms that you're agreeing to for your business. So, either saying, I don't know, I'm going to be creating a new business, and this is the type of business it's going to be, these are the number of employees, that type of stuff, or I'm purchasing an existing business, this is what I intend to do, this is how much I'm investing. That agreement, this is where you sign it. And then once you have that performance agreement signed, they will issue you a document that allows you to apply for the work permit. Again, technically, you could be denied the work permit. Usually, if you have one of those letters, they give it to you. But let's say there's some inadmissibility issues that your client forgot to mention. This is where they could actually be denied the work permit as well. So just keep that in mind. Nothing is guaranteed. Just because you get anything from the province doesn't guarantee the federal government will cooperate with you. So you have to apply for the work permit within 2 months of receiving that approval letter. 2 months is not a very long time, so make sure your clients are ready to move on things pretty fast. Once the work permit is issued, you basically have to arrive in Nova Scotia within, I think it's 12 months, and then you have to, when you arrive, you have to report to Nova Scotia within 60 days to show you've established yourself. They want to make sure that you actually are here and are starting your business. And the business must be established within 6 months of your arrival, which is actually not a long time. If you're purchasing an existing business, it's fine. But a new business within 6 months, to me, is a very short amount of time. Now, it's not that the business is already actively running, but you have to establish it. So make sure, before you even submit these applications, that these are real intentions that your clients have. Any client who says to me, oh, just tell me what business to open, I know that this province is going to be a problem for them because it's such tight deadlines. You've got to make sure that this is like a real thing that they want to do, that they're willing to get their hands dirty, that they're willing to act immediately. It's just too tight of a deadline to let it just be a pipe dream that we'll see what happens. Some provinces have longer times, this one does not. So once the business is established and it's been an active operation for at least 1 year, then you can officially apply for your nomination. So that's when you go back to the province, you submit the official application, you show the business has been established, it's been doing business for 1 year, it's all active, you're providing like salary reports for all the employees, you're submitting financials, depending on the tax season, tax documentation, you're providing invoices from the business, proof that you have either services or products being provided, like it's really, really in-depth. When you're doing that, you're not just providing it to the province, you also have an auditor at this stage. So you had basically an auditor reviewing all your net worth. Now you have an auditor looking at your business to make sure it really is actively. You can't just create these things. You can't just create fake statements. You can't just, generate income through other sources. There's a list of auditors you can use. You have to use one of them, and they will go through everything with a fine-tooth comb to make sure that this is real and legitimate. If the auditors see the business maybe either is not going to succeed beyond that first year that you've been scraping by, that it was just barely made it, they can actually issue a negative report, which would mean that you'd be denied your nomination. So it's, again, if your client isn't interested in doing a real business, this is not the province for them. So the province usually reviews the nomination applications within approximately 6 to 9 months. If it's approved, you then have 6 months to apply for permanent residence through the federal government. If they intend to deny, then you have 10 business days to respond. Interestingly, you will notice that that option wasn't available in one of the earlier steps. So the step where right before they schedule an interview to meet with you, like when you're not in the official nomination, but when you're just in that like review, give me a work permit so I can show myself, if they intend to deny, they technically don't have to issue you a fairness letter. They can just deny you and you have to start all over again. They only have to issue you the fairness letter at the nomination stage, because the first one wasn't a real nomination. It was like an intent to nominate. That's the difference, and I think that's how they justify not being required to give you the fairness letter. And then after landing, you have to provide a bunch of documentation to show that you are still staying in Nova Scotia. And you have 30 days to do that. So, as I said, the first step is you have to do the expression of interest, so it's an online process. Everything you put in that expression of interest will follow you, so make sure that it's accurate. Any points that you're given based on that information, if they discover that you weren't entitled to those, you'll just be denied and you'll have to start all over again. You have to constantly update it if you're not chosen right away, so you've got to make sure that you keep it accurate at all times. If, after you've submitted it, your points significantly change, I guess maybe they're still working on it, hopefully it will change, but right now they don't have a way to update it. With the Federal Express Entry system, you can usually update things so that you get more points. With Nova Scotia, they have a system that doesn't really quite work that well, and they basically tell you to just withdraw it and start all over again. You will remain in the pool for about a year, so hopefully you're selected within that period. If not, again, it will be canceled out and you have to start all over again. Draws are held approximately once a month. Sometimes it's once every other month. And the results are posted on the Nova Scotia website. The last draw they had was in December, and the lowest score selected was 91. So the way that you get points is that you get points for your language, education, your business ownership or senior management experience, your net worth, age, adaptability, and then there's two fun ones, which is the Nova Scotia Economic Priorities. So they have their own list of things that they would love for their province, and you get extra points if you meet one of those. And then for the investment. So the minimum you have to invest is $150, but the more you invest, the more points you get. So you can have a client who meets all of the requirements of the entrepreneur program, but they're not going to be selected because their points aren't high enough. So maybe their points aren't high enough because their English isn't the greatest, or maybe they've aged out. They don't get as many points for their age. You have to look at the whole thing. It's not that there's like a cutoff. It's like Express Entry where they use the CRS scores. Is that if you have a score that's within what they've been selecting, you have a good chance. If you have a score that they haven't even ever hit that, your client probably will not be selected from the pool. So make sure you're looking at the history of scores selected to ensure that your client has a real chance. If the government of the province has never selected anyone with a score under 60, your client has 60, really and truly, do you want to put them into a pool for something that will probably never be selected under? You got to think about it and do what's best for your client. So I wanted to talk about 5 important documents for the entrepreneur program. The first is the net worth verification report. This is where I told you need it up front before you can get your work permit. This is the thing where the auditor will look at everything. It will include a very in-depth report of what your net worth is and if you legally obtained it and how you accumulated it. That's why I said if your clients can't provide a paper trail, you're in trouble. So if your client, let's say, all of their net worth was mostly from the purchase and sale of properties and they've never kept any of that documentation, that report will not be positive. You've got to make sure they can trace it. It does cost to get those done. They do vary by whomever you're using, and the client has to pay for it themselves. The government does not provide any assistance with that whatsoever. It's just an extra cost that's on top of. The other thing is everything that's in that report has to match which is A in your application and B in the EOI, the expression of interest. So if you said your net worth was, let's say, $1 million, and you got points for that in the EOI pool, and you were selected based on that, and then you go and submit your net worth report, and the auditor says, well, actually, no, your net worth is only $600,000, which is the minimum, but it's still not that million, your application can be denied because you were selected, you were given points for having that higher net worth. But because you can't prove it here, you got to start all over again. So you've got to make sure before you even start. I always have clients say, well, just put me in the pool, put me in the pool. We'll worry about everything else later. You can't do that with a Nova Scotia. If you do that, you will be ultimately denied. And if you're found for misrep, you're banned for 5 years from the province. The other one is the business establishment plan. This is where you outline what type of business you want to develop. This is before you're approved for the work permit as well. This is where you're showing basically everything you intend to do. So the industry you intend to get into, the location, approximately how many people you need, what the costs will be, maybe what service providers you intend to use. There's a very big list that outlines everything that has to be included in that business plan, and you've got to make sure it's included. You can technically make changes to the business plan, which usually is after you've arrived in Nova Scotia, you've started the business and you realize, I thought I would only have to invest $150. I realize I need double that. It's a change, but one that they'll usually approve because it's the benefit. Or if you've said, I'm going to be hiring 5 staff, and you realize the business doesn't warrant 5 staff, I only need 3, you would have to make sure you get approval from the province that it's okay that you can change those components. So you've got to make sure any changes that deviate from that plan, you report to the province. This is a list of the things that have to be included in that plan report, so just make sure that you go through that list in detail. If you go through the application guide, it gives very specific examples of things they're looking for under each of those headings. This is just a general summary, but the guide gives very, very, very detailed examples. Make sure you follow it. Technically, you can hire someone to assist you with that business establishment plan. Just make sure that later on, when you hire an auditor, it's not the same person. They see it as conflict of interest. So if you hire someone to help you create your business plan, And then later on, when you've established the business, you have to find a verifier, and they're approved. Unfortunately, you're prevented from using them. So just keep that in mind. The other important document is the business performance agreement. This is if the interview is successful, you'll have to sign this. And this is where it outlines the things that you've agreed to do, such as the amount of the investment, the business sector you're going to be working in, location, your job creation plans, and any other details that are relevant to the business. They're contained in this. And this is what you would have to meet to get that nomination and permanent residence. Then the other one is the arrival report. This is once you have received your work permit. You have 60 days to report to the province and provide a ton of documentation to show that you really are intending to set up that business. The audit opinion report is after the business has been established and actively going for the 1 year. This is the report that you have to hire a certified auditor to review. They're going to look at the financial viability of the business, any concerns that the auditor has, maybe that their business isn't going to do well, maybe it's a violation of some laws. You've got to look at it. They will basically tell the province the truth. So if they have concerns, they will let the province know. They might have concerns and say this could be easily fixed if the applicant does this and this and this. And the province might be fine with it, but tell you have to meet those requirements. So once you've submitted the audit report, once the business has been established, everything's fine, you've received the nomination, then you can apply for permanent residence to the federal government. And those are taking, again, approximately 15 to 18 months. So that was the entrepreneur. This is the last entrepreneurial program, and this is the international graduate. So this is basically for applicants who graduated from a post-secondary program in Nova Scotia of at least 2 years at a recognized school. They lived in Nova Scotia throughout the entire duration of their studies, which means distance courses are not acceptable. You can't also do any compressed programs. It has to be a real full-time 2-year program. You have to be on a valid postgraduate work permit. You have to be at least 21, have a CLB-7, and obviously intend to live in Nova Scotia. Your business had to have been in operation for at least 1 year continuously, and you obviously had to have been actively managing it and running it. You have to own 100% of the business. You cannot be partners with anyone else. 100% equity owned by the applicant. You have to be, again, day-to-day activities in it, so you can't own the business and then hire someone else to run it. You had to have been doing that yourself. And you have to receive a salary. So if your business, sometimes in business, you can't afford to take a salary because that's just how businesses run. Under this program, you'd be excluded. You have to be receiving a salary, and the salary has to meet the LICO requirement, depending on the size of your family. Now, LICO, the requirements aren't, astronomical, but depending on the type of business you have, it might be very difficult to prove that. So you might have to wait until you've operated the business for 2 years before you can apply under this, just so that you can receive that salary.
And the first is bankrupt and then...
Exactly, I know, it's a very tough requirement. The other thing is, the business had to have been started as a career objective, which they don't really define, but basically to me, I interpret it as it has to be something that's either related to your education or related to your previous experience. You have to show a link. If you don't, they might say, well, you just created this for immigration purposes. It has to be a for-profit business. It has to be in sound financial health. If the company is going bankrupt or it's not doing well, you might not qualify. It has to be a permanent business, and it has to provide a significant economic benefit to the province. It can be either a new business, or you can purchase an existing business, similar to the regular entrepreneur program, and franchises are allowed. So to be honest with you, I would probably say purchasing an existing business is probably your best option, just from the financial perspective of it. If you are purchasing an existing business, it has to be in operation for at least 5 years before you purchase, and you also have to offer similar conditions to the existing staff. There's again a list of ineligible businesses. They're pretty much the same as the regular entrepreneur. The main difference that I've noticed is they add joint ventures between program applicants. So again, you have to own 100% of the business anyhow, so it kind of makes sense, but just make sure that you're not in it with someone else in any other way. The application process is much simpler than the other entrepreneur. You again do the expression of interest. And then if you're selected, then you apply for nomination directly. And you again have to include the audit opinion report. So you need that auditor to go through your business. It's not the net worth auditor, it's the business auditor to make sure that it's in sound financial health. If it's positive, you'll have to do an interview. And then you sign the business performance agreement. And then if you're approved, you apply for permanent residence within the 6 months of the nomination. So it cuts out that work permit stage. So it's a lot more fluid. It's a lot quicker to go through. But you had to have already established the business. That's why they cut all of that out. Expression of interest, it's the same as the federal. The only difference is that the points you get, the factors are slightly different. So you're not getting points for net worth because it's not relevant here. You're not getting points for the level of investment because it's not relevant here. And also, they have draws less often with this one. I noticed this one is around every 3 months or so that they have draws. So they just don't select people as frequently. Documentation-wise, there's a ton of business documents you provide. They don't care so much about your background. They care more about the business, that it's doing well, that it's been, it's gone through, it's sound financial health. You've got staff, you've got everything. The laundry list of documentation is for the business. And you still have to provide the auditor report, so you've got to do both. And again, once you get your certificate, you apply for permanent residence. Again, you can still be denied at the federal level if there's any concerns about inadmissibility, inability to economically become established, or withdrawal by the province. And I'm not 100% sure here, but I'm pretty sure that you would qualify for a bridge open work permit under this program once you have applied for permanent residence, because you're already here with a work permit. That's how you qualify. You've been given a provincial nomination that's not employer specific. So and as long as you're applying within the 4 months, you should be able to do that bridge open work permit. I haven't tested it, and I know that they've really cracked down on giving bridge open work permits to provincial nominees, but I don't see how this particular program would not meet those requirements. And we've already gone through this, the intention to settle. I emphasize it over and over and over for a very good reason. If your client is not going to settle here, they will be denied. Nova Scotia looks at it very carefully. You can't just say, oh, I intend. You actually have to give statements in your own words and give examples of what you've either done already or are planning to do to show your intention. When you're looking at best options for clients, as I said, my firm uses a very in-depth questionnaire, and our questionnaire is not designed for each province. We use we use two. One for just express entry, because we know that they have no real business experience, and so we use that to assess under some of the employer-based ones. And then we have ones for people who have business management experience, which we can use for entrepreneurial. But either way, it asks a ton of questions, but you do so because these programs are so specific. You're not just looking to see if they have, if it's entrepreneur, you're not just looking to see if they have the net worth and the investment ability. You need to calculate their expression of interest points, or there's no point in doing this. So make sure when you're gathering information from your client, you're gathering as much as possible up front, which is why I always charge a consultation fee, because that's a ton of work. This is not like a 5-minute review. This is a very in-depth process. You're doing a disservice to your client if you're not paying attention, if you're not spending the time, if you're not looking at all available options. The other thing I do is if a client tells me, I want to do the entrepreneurial in Nova Scotia, I'm like, yeah, that's great. And then I assess them first under express entry. Because no one wants to go through the process of establishing a business if they actually qualify under something else. Sometimes people don't realize they qualify under a simpler program. It doesn't happen all the time, but I've actually had it happen quite a few times. People in their 40s who think that they're too old for express entry, but they maybe years ago studied here. Maybe they have French skills plus English. Maybe they have a family member here where you get these points for express entry. They might qualify for that without having to worry about ever establishing a business here. So I always start with the easier ones, and then I whittle my way down to the more complicated programs. And the other thing is, I always make sure my client fully understands what their expectations will be, whether it's job offer-based Nova Scotia, entrepreneurial Nova Scotia, whatever it is. I make sure that it's outlined in black and white so my client can't come back to me later and say, I didn't know I had to do that. You don't want that to happen. You just spent hours and hours and hours of time preparing applications just for them to at the last minute say, well, I didn't think I'd have to do that, and pull out on you. So make sure they understand up front. And if things change with the province, make sure they're aware of those changes. Don't tell them at the end, they will not be happy. And that's it. Any questions about the entrepreneurial programs?
Yeah, I have a question. Number one, the $600,000 talked by NATO. Donation and inheritance, they will consider, because some programs they accept it, some programs without accept. Donation and inheritance.
I don't think that Nova Scotia excludes inheritances as long as you've got the documentation to back it up.
Sure.
If you can, exactly. I've never tested it personally, so I can't say 100%, but I've never seen anywhere where they specifically exclude it because it would have been legally accumulated. So I don't see a problem with that.
In this situation, entrepreneur, you need 3 auditors, actually, and you need to hire and you should pay, right? So one auditor for network, another auditor for business plan, another auditor for something. So everything is going your own pocket.
It's technically only 2 auditors that are mandatory. The third one you're talking about is someone who's helping you with the business plan, and that's not mandatory. The other ones are. And yes, 100% it's all out of your own pocket.
Since when this program is started?
I don't know the exact date, actually. I'm not sure. I did it before. It was when it wasn't through the expression of interest. So it's been around for some time, but they've changed it many times. The program was closed for quite a while, and then it reopened again with the expression of interest.
Yeah, talking about the auditor, can you give us a ballpark figure how much would that cost for each of the auditor's report? Thousands or tens of thousands? Or?
I'm pretty sure, I'm trying to remember. So I always tell my clients that they have to do it directly. I don't act as like a middleman for that.
Yeah, but we have to tell them the ballpark figure. What's the budget for that?
I think the client told me once maybe it was a couple $1,000s, but I can't remember 100%. Because I'm not facilitating it, I don't look the receipt. I mean, I get the report, that's what's more important to me. But I think the client complained to me once that it was a couple $1,000s. But fees vary, obviously, between them.
What do you mean for the international graduates, entrepreneur? What do you mean in compressed program?
So those are programs where it's maybe a 2-year program that you do within like a year and a half, like the accelerated programs. I think those are excluded.
Example, if you have like 4 semesters, but you study through the summer to make it shorter into 3.
I think that can be considered compressed as well. I think they really want to have lived in Nova Scotia for at least 2 years before you do the business. Unfortunately, I'm not sure 100% because they don't give a very descriptive detail of what they mean by compressed. You'd have to contact them to ask if that would specifically meet the requirement.
Right, but like for the PGWP purpose, if you have a 4-year program but you study 3 years to finish the whole thing, so you'll still...
You get credit for
right?
Yes, of course. But with Nova Scotia, because they use the word compressed, it could actually encompass that. I've never tested that theory. I've not done one under the international graduate. It is newer. I haven't physically, none of my clients have qualified yet under that particular program. That's why I haven't tested it.
So are you obligated to disclose all of your assets?
Yes.
So then when we prove the legal accumulation of the assets, so you have to prove everything you approved, you provided or disclosed, or you only need to prove the 600,000.
So I have not tested that theory under the current program where you actually need an auditor. When I did one where a client had stuff that he didn't want to disclose, it wasn't my file, it was a colleague of mine under Nova Scotia. Before they had that official auditor requirement, my colleague told me that their client hadn't told them about a couple of other businesses that they owned, that they were generating income from, because they were above and beyond what the minimum was, and they were denied for failure to disclose those. So.
The business doesn't have to be the same field, like if he's engineer and he wants to operate a laundromat.
You mean for the international graduate one?
No, for the...
For regular entrepreneur? Regular entrepreneur wouldn't be a problem as long as you can demonstrate that you have the ability to actively operate and manage that business. So if you can show that you're able to through your previous experience, it might not be related to your education, but maybe your experience is transferable. But for the international student, that's where you might have a problem.
One more question. The funds, like if he has assets of 600,000 in property, then he comes here and his sister gives him the 150 to operate the business.
No, it's personal funds, not sister funds.
But inheritance is fine, right? So they said.
But that's not an inheritance.
It's a gift.
That's a gift. That's not the same as an inheritance.
So gifts are not allowed for the
No.
of the property.
No, inheritances and gifts are two completely separate
I
things.
understand, but for the property, now we'll go back to another question. If the property is a gift from the father, still alive, but you want to divide all his assets with children.
I suppose if you can show that and then the net worth of it, but that's still not the same as putting the money towards the investment because it has to be your personal investment. You would have had to liquidate that property and then it becomes your personal investment.
Okay, or his sister has to give the money before he applies.
No, because you have to trace it all. It still would be considered a gift.
For the student, graduate student, once the studies are completed, they get a work permit, as in everywhere else.
Yeah.
With the work permit, would they be allowed
Of course, it's an open work permit. Postgrad work permits are all open. You can do whatever you want under
so
them.
they can make an investment in a business?
Of course. The only time that that's a problem is when you're doing the federal express entry, because self-employed Canadian experience doesn't count for points. That's why people are probably hesitant of using it for self-employed purposes. But a postgraduate work permit can be used for any legal employment. You can be self-employed, you can be an employee, it doesn't matter. It's not tied to anything.
So it's okay if...
Yeah. I actually have had a lot of clients who were self-employed under the postgrad work permit, and it hurt them for the express entry.
Yeah.
So...
But it's kind of time restricted. But they, say, for example, someone studies for 2 years, a 2-year program, has a work permit for 3 years.
Yep.
How could he make it in the 2 years, a profitable business?
Well, that's a completely different question. That has nothing to do with the nature of his work permit. That's just to do with, can he operate a business that's going to meet the requirements? That's why I said it's probably a lot easier to purchase an existing business, because starting your own and being financially sound within 3 years is really difficult. Yeah.
But you can put lump sum money as an investment of the business and salary yourself on that.
I don't know if that would actually work, because remember you have an auditor who goes through the business.
But when you open up a business, right? So
No, you can do that, but you can't use that to hide any problems with the business. So the business isn't generating sufficient income. They're going to say this business is ultimately going to fail because it's not in sound financial health. So I think that's where you could have a problem with that. Yeah. Okay, excellent. Thank you.
Thank you.